If we change how you look at it and realize that estate planning is an empowering experience, it is taking control. It is continuing to have control of your life from now and until the end, because you're sharing with other people exactly what you want. We have been in control of our lives this long. Why pass it on to, a family member, or why pass it on to a court to decide what happens to us, etc. And so one of the things that I want to do is just break down estate planning. So there are 4 corners of an estate plan. That's the best way to look at it. The first corner is the power of attorney. How many people have a power of attorney? All right. Power of attorney is a very important document because it empowers somebody to actually speak on your behalf. So right at this moment, those that do not have a power of attorney, who can speak on your behalf in a case of emergency? Who has the legal, there's a difference, who has the legal authority to speak in your behalf? Who has the legal authority to access your confidential information? Okay? I often hear clients say, well, I go to the bank with my mom all the time. My mom and I go to the bank, the teller gives us the money, I know the teller very well. I went to the bank the other day without my mom, I was still able to get money from her account. Why do I need a power of attorney? That is based on a relationship and familiarity. That's not based on law. That teller is used to you and seeing you and your mother together. And because of that, because of her experience and her personal knowledge, she is going to go ahead and give you the money without asking for that legal document. The problem arises when that teller isn't there. And all of a sudden you're faced with a new teller that has never seen you and your mother, and you're walking in there thinking everything's going to be okay. You need this money for an emergency situation, and the teller says, I'm sorry, but your name is not on that account. And so I need a piece of paper, a power of attorney, to give me authority to give you this money. It's all about liability, right? She gives you this money without the authority, and she could get sued, right? The institution's not going to go ahead and take that risk, not for us. And so that's one thing people run into. The other thing I see is they put their daughter or son or whoever on their bank account with them. That is a big no-no. I'm going to tell you right now, please do not put your loved one, your daughter or your son on the account. And the reason being is this: you put their name on that account, they become co-owners. That is why we have a power of attorney. Co-owners, they have the exact same rights as you. They are part owner of that bank account. And so the issue is this: if something happens to you and you pass away, guess who gets that bank account? Your child. What if you have other children? You have 3 children, you have 1 on the account, they automatically get the money. By law, they do not have the legal obligation to share that money, which would then go against probably your estate plan, which was that all your children share equally, right? And so that's just an example. That's why we have a power of attorney. There are 2 different kinds of power of attorney. There is a springing power of attorney, and then there is an immediate power of attorney. The springing power of attorney jumps into place upon 1 or 2 things happening. Either 2 doctors say that you can no longer handle your affairs, or the court's involved, either through a conservatorship or a guardianship. That's it. Most of the people have a springing power of attorney because they don't want that person to have automatic, immediate authority. What they want is when something happens and they need help, that agent that they've designated can spring into action and help out. Okay? So that's the power of attorney. The second corner is the Advanced Healthcare Directive. And I'm pretty sure many of you know about the Advanced Healthcare Directive. The Terry Striva, Florida case. Husband wanted to let go, parents wanted to hold on, the hospital said, we're not going to get involved. You figure this out, you go litigate. Do you know that it litigated for 15 years?
Oh, God.
She was on life support for 15 years. $80,000 a year back then, which is a lot of money. Okay? And so since that case, they came up with the Advanced Healthcare Directive. The purpose of the Advanced Health Directive, along with actually all of these documents, is this. You speak ahead of time. You answer the questions in advance that your family members are going to be asking. What would mom want? What would dad want? What would my brother want in this situation? He can't talk right at this moment. Does he want life support? Does he want to, he's going home. Does he want to stay home as long as possible? He can't care for himself. Do we need home care providers coming in to take care of him? Or does he want to go to the assisted living facility? Paradise Valley. He mentioned it in the Advanced Healthcare Directive. If I can no longer take care of myself, I want to come to this assisted living facility. Our job is to make it easier for our loved ones. And this is another document that's so important because it's sharing your thoughts in advance. There's a difference between the hospital Advanced Healthcare Directive and your private one, okay? A lot of clients tell me, I walked in the hospital, I was getting knee surgery, they made me sign an Advanced Healthcare Directive, am I set? No, you're not. Because that document is for that time. You walk out of the hospital and you're done with that surgery, that document no longer carries, all right? So you don't get lulled into the false sense of security that since you've already been in the hospital already has in my record that I have an Advanced Healthcare Directive in place, all right? And then the other thing is the private Advanced Healthcare Directive that you draft, it talks about your home care. Like I mentioned, where do you want to go after hospitalization? If you can't stay home and take care of yourself, do you want home care, like I mentioned, someone to come in? But then also, if you can't stay home, then what's next? Do you want to go live with your children? Do you want to move back where you were, originally raised with family members? Or do you want to go to an assisted living facility? These are questions that your loved ones, and maybe you've all experienced at some time, you've run into. And you're sitting there going, I know we had a really brief conversation about it, but wouldn't it really be nice to have it written down? That's the purpose of these documents, okay, and why they're so important. So when we're talking about estate planning, the first two most important documents, as far as I'm concerned, is your power of attorney and your Advanced Healthcare Directive. Go ahead.
If you have a healthcare directive in your trust, in trust, and you do another one at the hospital, which one takes precedent?
The one at the hospital is the one that's immediate. So if it's an old one, your private one takes precedence. Meaning, you have a private one, you've had it, but you go into the hospital for a specific reason, and they say, hey, here's the Advanced Healthcare Directive. That is dated, that is the most recent date, this is what you want today. They're going to respect that. Does that make sense? Does that make sense? That's the one that will take precedence. Exactly, because the moment you walk out, you're done with the procedure, you want that other one sitting there because it talked about home care, it talked about where you want to go, etc. All right? Yes?
So who all should have copies of the Advanced Healthcare Directive?
So who should have a copy of the Advanced Healthcare Directive? Your agent, your designated agent should have a copy, and your doctor. Your doctor will put it in the system. The hospital finds out that you're seeing XYZ. They'll scan it and send it to each other. All right. But your doctor is the most important, quite frankly. Your agent, obviously, because they're the ones that are going to move forward on your behalf. Okay.
Would you define agent, please?
Your agent is someone who you designate to represent you while you cannot speak, while you're temporarily incapacitated. All right?
That can be the same as trustee?
Exactly. A lot of times there actually are the same people. He asked if your agent for your Advanced Healthcare Directive could be the same person as your agent for your trust, your successor trustee. And a lot of times it is because it's family. That's what I see. Or now, let's go to the next corner. We have a will and we have a trust. Let's talk about a will real quick. How many people just have a will? Okay. So, the will used to be sufficient. I'll tell you right now, many people just have a will. The thing about a will is this. there are two big issues behind a will. One is that if your estate is over $150,000, that will not work. All that will is deemed is a mere nomination, a mere suggestion of who you want to represent you in your estate. Okay? Does that make sense? So up over $150,000, so if you own a home, you're out. You need a trust. Because what's going to happen, the very reason why we create these documents, the will and the trust, is to avoid probate. And I will talk about probate very briefly at the end. And so guess what? If you have an estate that's more than $150 and you have a will, we are filing a small probate. We are going to the court because it's a mere nomination. We're filing and we're asking the court, Your Honor, please recognize this document. Please recognize that this person that I've named is the person who's supposed to represent me. And then the court will issue something called letters of administration. Then you're able to go to the bank and carry on with the taking care of winding up someone's estate. All right, so the will, I just mentioned that $150,000, that's one issue with regard to the will. The second is it doesn't work until you die. A will is not operable. It had the executor that you've named in it is not empowered to do anything until you die. So it makes sense, that whole planning for your death, right? On top of it. So then what we have is a trust. The best way to look at the trust is this. You are incorporating yourself. You're creating a second entity. All right? You name it the Aloha Trust. And in the Aloha Trust, you put your car, well, you name your car in it, but you put your bank account in it. What you do is you put your house in it. You've incorporated. And the great thing about it is you've also named your officers. Just like we have a president, vice president, secretary, treasurer, right? The same thing you're gonna do. You're the president, which is the trustee. You name a successor trustee and a backup behind them. So if anything happens to you, guess what? Automatically someone steps up in your shoes and continues your estate, continues working for you. That's what's amazing about a trust. It's the continuity aspect of it. But that's just like one small smidge part of what's amazing about a trust, okay? The other thing is, in a trust, you could create sub-trusts. My daughter is 17, my son is 6. I do not want them to inherit everything at once. So I created a sub-trust for them that's tiered in distribution. Age 23, they're gonna get a third. Age 28, they're gonna get a third. 35, a third. That's one great thing, yes?
What is the difference between a co-trustee and a successor trustee?
He asked, what is the difference between a co-trustee and a successor trustee? Actually, they could be the same person. It depends. The trustee, if you have a co-trustee, it's just somebody else that you're working side by side with, all right? So if you're married, your husband and wife, the two of you are partners, are co-trustees of the trust, okay? A successor trustee is the person that is named after you, just like the vice president, okay? So you got the president, and let's say there are co-presidents, and then you have the vice president, and why I said it could be the same is because you could have co-vice presidents.
The successor trustee assumes the responsibility upon your death.
Doesn't necessarily. He was asking, the successor trustee assumes the position upon your death. This is what's great about a trust. Great question. Is this, a trust is operational now, meaning it works today. I am the trustee, I am the president, I have named my officers. Anything happened to me, they will step up in my shoes. But what if I don't want to manage my estate anymore? I'm aged, my kids are adults, I don't want to deal with it. I'm going to retire. I will always own my trust. I will retire and my successor trustee will take over. And I'm still alive.
That's not true of the co-trustee.
Not true of the co-trustee? A co-trustee, so what happens is when you have a co-trustee, if one passes away, the other one remains on their own. A lot of times that's why people do that. You know, if you're married or you name a co-trustee, it's because the two of you want to be managers of your estate, and then when the other person passes, it automatically, the other person goes off. but you still name successors, people after, okay? So when you're thinking about your successor trustee or when you're thinking about your agent, usually arm's length. Your sister, right? Their aunt, their uncle, your best friend. And then, depending on the size of the estate, and if you don't want that, or maybe you don't have anyone, we have fiduciaries. We have private and corporate fiduciaries. There are two different kinds. A corporate fiduciary, US Bank, Wells Fargo, the trust department, they charge a percentage of your estate. They're pretty pricey, but depending on your estate and the type of management, if you have a whole bunch of stock and et cetera and investments, and you might need that in properties, right? Or you can get an independent fiduciary, which is a private fiduciary, and most of them are at hourly basis, okay? And so that's what you would think about with regard to who should I designate as my agent. Think about those things, okay? So those are the four corners of an estate plan. You got your power of attorney, you got your advanced healthcare directive, you got your trust, and then wait, there is another. I said will, right? It's called a pour-over will. And what it does is it's kind of the catch-all. It really takes the directions with regard to the pour-over will is saying, everything that I've missed in my trust, I'm gonna pour it in. That's why it's pour-over, quite frankly. When you read a pour-over will, it says, I give my entire estate to my trust. Another thing about a will and a trust is this. A will is public knowledge. Did you know that you need to, within 30 days of someone passing, you need to file their will at court? Many people don't. But you do. That's law. You're supposed to file and the reason being is it's a notice. It satisfies a notice. So if it's filed in court, guess what? It's public. Trust is private and confidential. And when you go to court and you want to look up Robin Williams, look at the trust and you won't be able to see it. So I know I also went over a whole bunch of stuff, but I hope I made some sense. Broke it down into four corners, 4 steps, the importance, advanced healthcare directive, power of attorney, and then your trust and your will. The other thing is that you're not done with that, and Jatana's going to talk about this part. You're not done with that because this is the thing. You have the estate plan documents, but if you wanted to stay home as long as possible, or if you want to go and live in an assisted living facility, do you have the funds? Do you know who to go to? That's the next step. Make sure you have the documents, you look at it yearly, update every kind of 2 years. Change of law is big. Don't get lulled into the false sense of security that it's all taken care of. Remember that fallout you had with XYZ yesterday? Well, you had named them as a beneficiary. Look at your stuff. But like I said, the next step is then the support. Because empower your kids to be able to make decisions for you because you've made them ahead of time. Empower your kids to the resources as well. All right, so thank you very much for your time.